And we still have a few people joining. I think we have like 32 people registered for this presentation today.
Okay.
Yeah, they're big, yeah. $6.99. These are $6.99.
There we go. All right. Sorry, guys. I'm in my vehicle, kind of wrestling with stuff in here. All right. Okay. It is 3:02, so we are on time. Okay. Hi, everybody. This is Teresa. I am going to start having all the folks say who they are for our meeting because it's helpful to know who everybody's on the meeting. So let's see here. How about Gigi? You start first. Tell us what part of your state you're from and how many years been a guardian.
I'm Gigi Calsa. I'm new to guardianship and I'm in Hillsborough in Tampa.
Okay, great. Glad you're here. All right. Sherry, you want to tell us something about you?
Sharima Holland. I Lake Marion and Sumter counties, and I've been a guardian almost 5 years now.
5 years. Great. We're glad you're here. All right. Taylor Scott, you want to come off a mute and introduce yourself?
Hi, I'm Taylor Scott. I am in Brevard County and I have been guardian for about a year.
Oh, so about a year. Okay. All righty. Okay. Then how about, let's see, Monica?
Sorry. Hey, guys. This is Monica. I'm in Broward, Palm Beach County, and I've been a guardian for going on 5 years.
We were
Happy
in
New Year.
Happy New Year to you. Glad you're here. All right. How about Carolyn DeWitt? Carol DeWitt.
Carol, can you see me? Because my screen is really funny with this. I'm Carol DeWitt. I work in Marion and Chester County, almost 5 years now. Yeah, I've been on these things before. Thank you very much, Teresa.
Glad you're here. Glad you're here. For somewhere, there's a lot of noise coming. Julie, is that from me? Okay. All right. Miss Karina, introduce yourself and tell everybody where you're from and how long you've been a guardian.
Savella, Brevard County, Central Florida area, and I've been a guardian since 2018 as a professional, working in the guardianship since 2000.
Glad you are here. Stephen, want to come off a mute and introduce yourself?
Hi, y'all.
Sorry about
I
the
am
noise.
a guardian representative for North Florida Office of Public Guardian, and I've been a guardian for about 2 years now.
Stephen, you said you're a guardian representative?
Yes, ma'am. I work as a public guardian for Duval, Nassau, and Clay through North Florida Office of Public Guardian.
Okay, yeah, great. Glad you're here. All right. Is it Talitha?
Yes.
Perfect. Where are you from, dear?
I'm from Brevard County, and I have been a guardian since the early 2000s.
All righty. Okay. Let's see here. All right. How about Amanda?
Hi, I'm from I've been guardian now.
We're losing you, Amanda. I'm not sure if you're sitting still or if you're moving around.
Are you hearing me or it's moving? So it could be bad connection.
Yeah, it's pretty bad connection. I'll just tell everybody, Amanda's from the Orlando area. There you go. There you go. All right. There are some people in here that are a phone number, and since I don't have a name, I'm just going to give a phone number. So whoever ends in 0288, who is that?
Hi, this is Kathy Saganik. I am in Lee County, and I've been a guardian for 9 years.
All right. Glad you're here, Kathy. who ends in 5302?
That would be me, Judy Mays. I live in Orlando, and I've been a guardian for over 30 years.
All right, glad you're here, Judy. Kathy
Thanks,
Bowers.
Teresa.
Hi, I made it home. My company is National Patient Advocate, and I'm a nationally certified guardian, but I practice patient advocacy in
All right.
Plantation, South Florida.
Glad you're here, Kathy. Is that my computer's not making that noise, is it, Julie? I'm hearing this weird noise. Okay. All right. Laura Dickinson, you want to come off of mute and introduce yourself? Dickerson, sorry.
Hi. Yeah, I'm Laura Dickerson. I practice in Pinellas and Hillsborough and Pasco County. And I've been a guardian for 8 years.
Perfect. Glad you are here. Miss Kelly Pittman, introduce yourself.
Hi, I'm Kelly Pittman. I've been a guardian for 22 years and I work mainly in Orange and Seminole County. I have a couple in Volusia and 2 in Osceola.
Thanks. Glad you are here. Miss Betty Gall, you want to introduce yourself? If you want to introduce yourself, Betty, you got to come off mute. Oh, wait, she's tapping in. She says she's a guardian for 16 years in Marion County. Thanks, Betty. All right, Deborah Nichols.
Deborah Nicholas. I've been a guardian in Collier and Lee County for 8 years.
Great. Okay. Patricia? Did I lose you guys? Patricia?
We can
Nope.
hear you, but
Okay.
I don't.
Okay. How about Charlotte Hewler? You guys can hit the chat if you want to introduce yourself there. That's okay. If you don't want to talk, that's cool. All right. Tracy, Miss Tracy.
Tracy Spencer. I am the benefit specialist for Aged.
And when you guys use Aged and you need Medicaid help, she's the bomb. All right, Dina.
Hi, I'm Dina Carlson. I've been a guardian for about 5 years in Orange and Seminole.
Okay. All right, Gail.
Hi, I'm Gail Rapp. I'm the Director of Case Management for North Florida Office of the Public Guardian. We serve 23 counties, I think, in North Florida. And we do have a private guardianship practice also that we have started about 2 years ago. And I've been a guardian for 15 years.
Great. I'm so glad you're here. All right, Miss Simone.
Hi, everybody. Simone Whitkin. I'm a professional guardian for about 18 years in Palm Beach County and basically South Florida.
Okay. We saw Simone at the meeting at the judges panel this
Great
morning.
job. Great job today.
It was good. It was good. It was fun. Okay. All right. So there's a couple people that I called out but didn't answer. You guys want to try again? You want to say who you are and where you're from? All right. Sarah Shoemaker, you want to introduce yourself?
Hi, yes, my name is Sarah Shoemaker and I've been a guardian for about 5 years and I cover the North Florida region.
Okay. Diana Shields.
Hi, everybody. I am Diana Shields. I'm a guardian for 3.5 years now, and I cover Orange and Seminole County. And I just got back from the FSGA meeting with the legislators in Tallahassee this morning.
Ooh, we will talk about that at our next peer talk conversation. By the way, you guys, someday you got to look it up. Diana made some really fantastic forms that are in the peer group that deal with DNRs, withhold and withdraw. So we'll talk about that next time y'all come to the peer group.
Teresa,
Okay.
while I have a pause, Michelle Wright popped on the chat. She said she doesn't have a mic on her PC, but she works with Amanda Wright and she wanted to say hi to everybody. So.
Hey, thank you, Michelle. Okay. I think that's pretty much everybody. I don't want to take up too much more time of this. So one quick little blurb for our presenters. So I met Stephen Dunn, the father of the two, some years ago, and he helped me with a really messy long-term care insurance disaster. And ever since then, this is what these guys do. So we are so happy that they're here and telling everybody about how this stuff really works. So Julie, is there any more admin stuff we need to do?
No, I think we're good. And they can go ahead and introduce themselves and then Kevin can share his screen whenever he's ready.
All right.
We'll just start with the share first and then. Just want to make sure it's working. Can you all see that screen?
We
Yep,
see it.
we can see it.
Okay, perfect. So we'll get started. So thank you, Teresa, and thank you everyone for joining us today. My name is Kevin Dunn. This is my father, Stephen Dunn. We work
Hi,
together. We are attorneys, and our practice is primarily focused on long-term care, insurance, litigation, and disputes. So just on a personal note about how the firm initially transitions into this line of work, I think I'll let my dad explain how we first got it started in this field.
Hi, everybody. So I've been I've been a lawyer for 38 years, and for the last 15 or 16, I've devoted almost primarily to long-term care insurance. Before that, I was a maritime lawyer and did various other things. A personal matter arose concerning my father, his health, and he had a long-term care insurance policy. We were faced with a denial, so I had never seen a long-term care policy or anything like that. But I did take a look at it, and I decided to sue the insurance company for the denial, and we were successful. And that whole experience, not only in dealing with a sick father, a sick parent, but also helping someone like my father navigate through a very difficult process like long-term care insurance. And I made a decision shortly after that case that I think this is something I really need to do, and began to make a move in that direction. And that's the story. So here we are, 16 years ago, handling cases for providers, for individuals. We help guardians navigate through long-term care issues when they arise and so forth. So I'll turn it back over to Kevin.
So yes, like my dad said, since the time he initially brought a lawsuit on behalf of my grandpa, the firm's been involved in thousands of different long-term care insurance disputes. My dad's been able to make law in the state of Florida on long-term care insurance. And so today we're going to give over some of our experiences and hopefully help you better understand long-term care insurance. So I understand that everyone joining us today is already a guardian. So a lot of this in the beginning is going to be a bit redundant. The only reason I've included it is because I think all of these different types of duties tie into long-term care insurance. Long-term care insurance relates to issues of health, relates to issues of finances, relates to issues of where a person may live. So I won't even spend that much time on these slides. I just have the different duties of a guardian of a person on this slide. And then I have guardian of property on the next one. And so like I mentioned earlier, I think long-term care insurance really ties into almost all of these different types of duties. And so I think I narrowed it down on what I feel is the most important duties and how they relate to long-term care insurance specifically. So again, guardian has the duty to act in the best interest of the ward. If you use long-term care insurance properly, you can help meet that duty. Guardian has the duty to protect the ward's assets. Long-term care insurance is first and foremost a financial institution. So, if used properly, you can protect a ward's assets and make sure that stays in place. Another one of the duties is understanding different insurance policies a ward may own. So of course that relates directly to long-term care insurance. And then later on in the talk, we'll discuss how the process for engaging attorneys on behalf of a ward goes. So I included contracting or hiring attorneys as some of those duties that we're going to be talking about today. So I'm just going to jump straight into long-term care insurance. Now, if anyone has any questions, please feel free to jump in. We'd be happy to answer them. So I'll start generally with what is the purpose of long-term care insurance. First, it's to keep, in this case, I have you because I sometimes give this presentation to individual insureds, but in this case, the ward, it's to keep your ward as independent for as long as possible. And now when I give this presentation, oftentimes individual insureds are always a bit confused about this first one. Most people have the idea that long-term care insurance really only applies when someone's closer to end of life and extremely needy. A lot of people always raise their hand and say, I'm only going to use my long-term care insurance policy in the nursing home and that's it. And in reality, the way the policies are designed is that's not accurate at all. If you use your long-term care insurance policy early enough and properly, if done correctly, then that should help you maintain some level of independence. It sounds a bit counterintuitive because you'll be using your policy to receive some assistance, but the purpose of that assistance is to help keep the person healthy and safe so that in turn, you avoid catastrophic injury, you avoid not being able to take care of yourself. We have a client in the office. He was a longtime client. He recently passed away, but he called the office and said, I have this long-term care insurance policy and they've denied me. We've got into a bit of details with him and it turns out he was actually still working. And for this specific client, his care needs manifested early in the morning. So we were able to get the denial overturned. This particular insured got a little bit of care in the morning and then he went to work and he continued to work for about 5 years. So we use that as a perfect example of how a policy can help someone increase their longevity. The second purpose of long-term care insurance, I think I've already touched on it, is to keep the insured healthy and safe. I think that's pretty obvious and goes without saying. The third is to give the insured options for their care. Some people prefer to stay at home and get home care. Other people want to do the assisted living lifestyle. Most of the policies in circulation today will provide options for that, and people will be able to choose what best suits their needs. And lastly, it's to protect the assets of the insured. I think it's pretty obvious the cost of care today. I think everyone here is probably well aware of just how expensive it is. So if you use your policy at the right time, it can definitely, protect the person's assets down the road. So this is a big one. And I think it's really important for everyone here today to understand. The first thing we need to talk about is what type of long-term care policy do you own? So there's two main types. There's a reimbursement policy, and then there are indemnity policies. And the difference between the two is substantial. So for reimbursement policies, it's self-explanatory. The insurance company will reimburse you for the cost of care. So if you spend $100 a day, the insurance company will give you $100 back. Now, indemnity is very different. Let's assume the insured has a $250 a day benefit, daily benefit, but the cost of care for one day is only $100. The insurance company is still going to give that insured a check for $250 every day. So these types of policies can become cash positive. So they're income producing policies as well as policies that pay for care. The issue is that most of the policies don't specifically articulate the difference. You have to do a deep dive into the particular language of the policy to understand it. So for a lot of people that are worried about perhaps their policy is going to run out or they want to push using their policy down the road, they should not do that in an indemnity policy. They're missing out on an opportunity to become cash positive. So it's really important, first and foremost, to understand exactly how your benefits are going to be paid. And then just generally, coverages, it's less common today, but there are policies out there that are nursing home only policies. I think this is very important for guardians as well, because nursing home only policies in Florida are not really allowed to only provide nursing home coverage. Under the law, they have to provide lower levels of care in addition to nursing home coverage. So we've gotten plenty of calls from people that either want to use their policy for home care or assisted living, but they were denied because their policy is, quote, nursing home only policy. And we've been able to get those insureds approved in lower levels of care. The problem is the insurance companies don't necessarily apply the law the way they should. And so we tell people, if you have a nursing home only policy, that's not necessarily what you have. And you want to make sure that you speak to someone that knows what they're talking about and can assist you, because it's an extremely valuable added benefit for someone. Most people don't want to end up in a nursing home. They want to take advantage of lower levels of care. So for nursing home only policies, if you ever do happen to come across from that, just be mindful that there are other options available for that. Some of the other policies out there are home care only policies. These are becoming more and more rare, but these policies will only pay for home health aid inside someone's home. The interesting thing about these is that we've been able to get some home care only policies to pay for portions of assisted living. Now, I can go into the long, legalese of how we were able to do that, but the bottom line is we've been able to argue that assisted living is a person's home and that the care being provided in assisted living should count as home care. So we have been able to get some assisted living charges paid for under home care only policy. And again, that's also something to be aware of because again, the insurance companies are not going to apply it that way. You're going to have to fight for that. And I'm sure most of the policies you're going to come across these days are comprehensive. So they have assisted living, nursing home, home care, hospice, all of these other things. And then some of the newer policies as well contain ancillary coverages, so durable medical equipment. Some policies will pay for wheelchairs. Some policies will pay for even changing someone's bathroom into a wheelchair accessible bathroom or bathroom more conducive to someone that has ADL deficiencies. So a lot of these policies have other valuable benefits in them. You just have to make sure you look for them. A lot of them also provide life alert, so a pendant, they'll pay for that. Care coordinator services, which can be very valuable. I think I'm going to talk about it in another slide, but I just want people to be aware that care coordination is becoming more and more common in the policies we see in the office. The important thing to know about that is a lot of the insurance companies provide incentives to insureds to use care coordinator. So I think Genworth and John Hancock tend to be the most common ones for this. So what they'll say is if you use our own assigned care coordinator, we'll give you all of these additional benefits that you otherwise would not be eligible for. And those can range anywhere from a waiver of premium, waiving an elimination period, which I'll discuss later, paying 100% of the charges as opposed to 80. So you really want to make sure you understand a care coordinator benefit if it does come across a policy that you may be looking at.
Hey, Kevin, can I ask a question real quick?
Sure.
So when you said there's a Florida law about the nursing home only, is that something you could share with us just so we can read it at some point? That law?
Sure, I'll make a note and I will pass it along and make sure it gets out to you.
Okay, and I want to make a comment about care coordination. I don't know if you know this, guys, but there's some policies actually allow a care manager to be hired by the family, and it pulls some of the benefits out of that policy and it doesn't affect the daily rate. Kevin, do you deal with that much?
So we have seen a lot of care coordination benefits like that. A lot of our clients are a bit wary to use it, but we do recommend them using it. The issue with the policies, a lot of them require that you use a care coordinator provided by the insurance company. It's rare that I see one where you can choose your own. It comes up, but it tends to be on the older policies. But the majority of the policies I see today will pay for a care coordinator as long as it's one selected by the insurance company.
We've got a guardian care management. We've got a couple of the policies to pay it, and I am not a licensed clinical social worker, and I do not have a master's degree, and we've got them to pay. Not every one of them, but some of them have paid, just as a piece of information. And I think the argument can be made that a guardian is actually a care coordinator.
I was just going to say, I think a lot of the work that guardians do match up exactly with the work that a care coordinator does. In terms of the policy, it's really going to come down to how the policy defines care coordination, or perhaps you can get a guardian approved as a care coordinator, but it's always going to be policy specific, but that doesn't mean it's not possible. So I mentioned it earlier, but I'll talk about it in detail now, is the elimination period. So I'm not sure if everyone on the call today has come across long-term care insurance policies, but the majority of them today now contain elimination period provisions. So the way to think about it is like a deductible on a health insurance policy. The elimination period is a day that you have to need and receive covered care and pay out of pocket before the insurance company will start to pay the bill.
Period of time. 30 days, 60 days, 30 days.
Yeah, so I'm not sure if you heard my dad there, but the elimination periods can vary. They can be as low. Some will waive it altogether. Some will go all the way up to 120 days. The important thing to know about the elimination period is they're policy specific and the definitions are nuanced. So while it may say the elimination period is 100 days, you have to take a look at the definition of elimination period. One example is a lot of policies today say that if you receive covered services for 1 day a week, they'll count that as 7. So you have to be very mindful of how a particular policy is going to calculate an elimination period. And one of the main reasons it's so important to be aware is because the elimination period is a very expensive time for insurance. So if a policy has a provision that allows for someone to get more credit than they think they can get, then that may provide a substantial savings to them. And then part of what we do in the office is provide some strategies on the elimination period. One of the biggest problems that we see in our office is people that decide, I'm ready to use my policy, I'm going to move into assisted living. The problem with that is you have to get through the elimination period. So if an elimination period is 90 days, that means an insured is going to have to pay for 3 months out of pocket at an assisted living facility. That's extremely expensive. The price of assisted living can, range between $4,500 to way more these days. So what we tell people is if your policy allows it, and most of them do, is to start working on your elimination period at home. Get home care so you can slowly get through it. You can control the spend, but then you can also get used to receiving care. And then the added benefit is while you're working through the elimination period at your own pace, you can also get through the claims adjudication process. It's very risky for someone to move into assisted living and then start the claims process. We have so many stories of people that have moved into assisted living. They've sold their homes and they thought the policy was going to kick in and protect them. And then the next thing you know, they're 6 months out of pocket on assisted living and on the verge of homelessness. We have one particular case that really stands out. This woman lived in a mobile home. It was a nice mobile home, but not by any means fancy. She didn't have a lot of money, but she sold it. She made the move to assisted living, and she was denied. And the assisted living said, we're ready to boot you. We're going to evict, and she had nowhere to go. And she had spent all of her disposable income on the move, so she was in crisis. So if someone's doing this on their own, it's very dangerous to start in assisted living. So we really try to push the fact that it's more strategic to start at home. Another thing we want to bring up for the elimination period, I think this is also particularly relevant to guardians here, is to be cognizant of what counts as covered services for the elimination period. So for example, stays in rehab, even if paid by Medicare, will usually be counted towards the elimination period. So if someone's coming out of skilled rehab and then they're starting the claims process, you want to make sure that those days are counted towards the period so that you have less out of pocket and you can get the claim paying faster. So now we're going to talk about policy triggers, what it actually takes to qualify for benefits under this policy. And I think this portion of the presentation is going to tie into what I had said originally about the purposes of long-term care and keeping you safe and independent as possible. I think you'll see as we get through the triggers that it's much easier to qualify for benefits than most people think. So the first trigger that we're going to talk about is the functional impairment trigger. So the activities of daily living. In almost every policy, you're going to see at least these 5. Some may have 6, some may have less, but that's a different story. These are the 5 most common ones, which are bathing, dressing, transferring, feeding, continence, and toileting. Most of the policies are going to say you must need assistance with at least 2 of these activities of daily living in order to qualify for benefits under your policy. So what does that actually mean? If you look at the bottom of the slide, I think I've written out hands-on versus standby assistance. So this is exactly what needing assistance means for these activities of daily living. Now, the majority of the policies today are going to allow for standby assistance, which is a very low bar to qualify for. So for example, standby assistance for bathing is the insured can physically bathe themselves. They don't need anyone to physically touch them. They just need someone within arm's distance to make sure that they're safe. So think about it for people that are dizzy, fall risk, vertigo. They can bathe themselves, but sometimes they may be in danger of falling, so someone just has to be there to grab them. That would count as assistance with the bathing activity. And the same for dressing. It's pretty common in my office. There were people I go through what's going on in their daily life, and I always ask them, what are you doing for dressing? And 99% of the time, the person will tell me, I sit at the edge of my bed, I slowly put my pants and my shoes on, I'll grab on to the chair while I'm putting on my jacket. That's essentially providing standby assistance to yourself. I tell people the policy will allow someone to be there to grab you so that you can do it safely. They don't even have to, tie your pants or buckle your bra in order for you to get credit for the dressing activity. So a lot of people don't even realize that they're already at the point of requiring dressing assistance, at least standby. Now we'll go to transferring. Transferring is anytime you go from, for example, a seated position to a standing position. Think about getting in and out of a car, up and down from a couch, in and out of bed. And again, standby is the same. Someone just needs to be near you while you're doing that activity. Feeding for standby, it's harder to articulate. So I'll really just focus on feeding for hands-on, is you physically need someone to feed you. We've been able to make some interesting arguments about standby assistance for feeding, but it's a more difficult one to qualify for standby assistance there. And then there's continence and toileting. So some policies will just say if you have issues with bladder or bowel control, that in itself is enough to get credit for that ADL. Others will say if you require assistance with related hygiene, and again, it can be standby. So if you need help getting out of wet or soiled clothing, or someone needs to be nearby while you're doing that, that would constitute assistance with the continence or toileting activity of daily living. And then hands-on for all of these is self-explanatory. If you need hands-on assistance with bathing, it's a sponge bath, it's someone's washing your back, someone's washing your hair. If you need hands-on assistance with dressing, someone's physically tying the bra, putting on someone's shoes. Physical assistance with transferring, they're going to grab onto you while you're getting up and down. Feeding, someone has to feed you. Continence and toileting, they're going to help you take off your pants, they're going to help you do any related hygiene like that. So if you require assistance with at least two of these, and in most cases standby assistance is sufficient, then you can qualify for benefits under a policy. Now, the other way you can qualify for benefits under a policy is under the cognitive impairment trigger. So first, I want to make sure that we understand there's plenty of people that have dementia or a cognitive impairment, but are functionally okay, and that's okay. They're mutually exclusive. So someone can have a cognitive impairment, but be functionally okay, and they could still qualify for benefits under their policy. So the standard in most policies for the cognitive impairment trigger is if the insured suffers from a severe cognitive impairment in order to trigger benefits. However, the standard under Florida law, and which I think is a more fair standard, is that whether or not the impairment makes the person a risk of harm to themselves or others. Now, cognitive impairment trigger cases are more difficult because they're harder to prove. You're going to have to show some objective clinical evidence, show examples of why the person is a risk of harm to themselves or others. Some of the examples we use in the office is if someone is wandering or a risk of being lost, that's an obvious risk of harm. If someone's forgetting to turn off the stove, turn off, putting the hot water all the way up, things like that are obvious risks to the person's health.
Accumulated mail.
May I ask a question?
Sure.
This is Diana Shields. Have you ever come across this risk of harm to self or others Florida standard involving ALF waiver denials for Medicaid long-term care in the assisted living facilities?
That's not exactly what we do. So I can't say we have, because we don't particularly deal with Medicaid. That's something that we would rely on other people we work with. Perhaps I could ask someone that may know the answer to that, but that's not something I'd be comfortable giving you an answer definitively right now.
Would that sound like if they have cognitive impairments and can't really take care of their medications or contact their doctors, that sort of thing, that they would be at risk for their health if they're wandering and they can't figure out where they are with what's going on without those medications? Would that sound like something that would be a violation of that Florida law standard if the ALF waiver denies them for cognitive impairments rather than just like a cardiac disease? Should I be asking an attorney who might work with that sort of thing?
So I think that's probably best to do, but I just want to make sure that I'm clear on the Florida law standard here is I'm speaking specifically about long-term care insurance. I would have to check Medicaid regulations to give you answers on that. They may not necessarily cross over. So I think someone that
Okay.
deals specifically with Medicaid would be better suited to answer that
Okay.
question.
Thank you.
I lost my train of thought a bit. Okay, I know we were talking about the Florida standard, which always leads me into obviously warning signs that someone may be developing some issues. My dad mentioned earlier, I don't know if you all heard some of the things to look out for. So for example, if someone's starting to stack mail, if you walk into someone's home and you're seeing a big mess, erratic behavior like that, obviously keys in the freezer, things like that, those are all warning signs that something is creeping up.
Yeah, even more subtle, like, changes in hygiene, changes in appearance, changes in dress. Cognitive cases are complicated, so we always look to witnesses and people, lay witnesses, not just expert opinions, but also people who are familiar with the individuals to try to piece together the changes that are observed by people on the outside, and when you put it all together, then you make a whole case. So they're more difficult to perfect, the cognitive impairment claims, but they can be perfected, and we do when the evidence is there. So.
And I know part of what we were going to talk about today is the actual claims process. So I think what my dad just mentioned is a good segue for that. So if you are looking to make a claim under the cognitive impairment trigger, you have to start laying the groundwork pretty early. You have to make sure that neurologists have been seen, that their documentation is sufficient, and make sure that they're articulating exactly what the person's needs are. I think it's also important to know that a lot of the tests today, some of the mini mental status exams is what the insured is going to have to go through when they're undergoing an eligibility assessment. But that test is not really that sensitive. So if you know that someone's got some issues going on, but they're still scoring abnormally high or higher than you would expect, our suggestion is always to seek out a neuropsychologist. There's a battery of tests, a neuropsychological evaluation. Those tests are significantly more sensitive. And if it's a cognitive impairment case, you may want to consider doing that. That's probably the highest standard for cognitive impairment, objective clinical evidence. So for example, in the office, we had a client call us. They said, my mother has all this peculiar behavior. I know she's got memory issues. There's a lot going on, but she's scoring in the average range on a mini mental status exam. So if they were just to submit a claim with that, and along with some anecdotes that their mother's not doing well, that claim is going to be denied, which is what ended up happening. So they called us and they articulated all of these issues, and we suggested that they take her mother to an evaluation. And the results of that evaluation were completely different than a 30 out of 30 score on the mini mental exam. Her results in that particular case showed deficiencies in executive function, in memory impairment, language impairment. So all of these things that a mini mental exam test is not going to pick up were picked up in these more sensitive tests. So we were able to articulate that, yes, there is a basis for this behavior and that she does in fact need assistance and supervision due to her impairment. So, and it just reminds me again, I just received a similar case where someone went to a neurologist, and some of the doctors these days just tend to see the person, write down what they're saying, and move on. So her records don't really reflect what's really going on. So it's going to take some work to go back and backtrack exactly what's going on. So you don't want to submit a claim before the supporting evidence is in place, because it's just going to cause problems. Cognitive impairment trigger cases require some strategic planning before just submitting documentation for the claim. And honestly, to that point, which I probably should have mentioned for the functional, the same is true for an ADL trigger. I'm seeing after COVID, a lot of seniors avoided going to the doctor for a while. So there's huge gaps in medical records. So insurance companies are grabbing onto that as a basis for denying claims. So the insured will say, I have all of these issues. This is what's going on with me, but there's no medical evidence to support it. So the insurance companies will say, we're denying your claim. We don't see anything that backs up what you're claiming. So again, if you're going to make a claim, you really need to make sure that medical records are there and support exactly what you're claiming on your claim form. So I'm going to talk about premium increases, which also ties into policy lapses. So this is very important for guardians, and it ties into the financial aspect that we were talking about before. So if you have a ward who has a long-term care insurance policy, the chances are that you will be getting a premium increase notice very soon if you have not already. So what's going on now is almost every major insurance company is requesting and receiving permission from the state to issue these, quite frankly, massive premium increases letters. And what's happening is a lot of people are either compromising their benefits to a degree that, quite frankly, is unacceptable and would not cover their care, or they're stuck paying extremely high premiums, which is just draining their accounts. So what we tell people first and foremost is before making any decision about a policy, you really need to understand what you have. I tell people all the time, a lot of people call the office, I'm receiving this premium increase notice. I think I'm just gonna check one of the boxes for a lower premium. And what those people don't realize is the sacrifice that they've made to save some dollars now. One insurance company in particular is sending options that are almost half the value of the current policy. So what I like to tell people to do is, well, let's back up first. Let's look at what you have. First and foremost, it's a expensive financial instrument that you've paid a lot of money for. So let's understand exactly what you have, and then let's go over detail of what the options that they're providing you for. So I think it's the same for you. If anyone that you're working with is receiving these notices, you really need to be aware of first what they have and what the options really mean.
Kevin, I want to say something about that. Guardians, I'm not sure if everybody realizes this is where the whole liability thing of making financial decisions for your ward. If you were to receive one of these letters and you made the decision to check off that box and reduce the premiums by maybe half, it's a lot. Sometimes it's 50%. It's a huge amount of money. And then that meant you were basically cutting their benefits in half, which is pretty typical. You've made a big financial decision. Don't make that decision without your attorney from the guardianship being involved, or somebody like Attorney Dunn to help you make sure that, yes, it's going to cost another $65, $75, $125 per month because they're increasing the premium. But what did you walk away from? It's a lot of money. And I right now in the care management world, I have clients coming to us all the time who say, well, we're just gonna not pay that premium anymore, or we're just gonna take the half premium. And I'm like, stop, please don't do that. You paid this policy for 17 years. Your mom is 91. The odds of her filing a claim in this policy in the next 3 years are 100%. So, but they're written terribly. They're so convoluted. It's so hard to understand that they make the words very squirrely to make it where you'll choose the wrong box, which is their goal.
Exactly. I think that hits it exactly on the head. I have a client in mind that called us after they had made a decision. I think we were giving a talk in the Villages area, and I always really hit home on this premium increase issue because I know all those people are getting these notices. And he comes up to me afterwards and he says, can you take a look at my options here? Did I make a good decision or not? And the thing I hate doing in our office is telling someone, you basically gave up $250,000 in value to save $2,500 for the year. And those people are just shocked because the lapse notices that they're receiving, like Teresa said, are very convoluted. They're very hard to understand. They're framed in a way that you don't exactly realize what you're giving up. And when someone actually articulates what you've done, they're shocked. And for many people, it can be a disaster. If you had a financial plan that was relying on X amount of dollars and now you have a fraction of that, you're still going to have to find money to pay for that cost of care. So really,
yeah, it's a big deal. And I think for guardians, the other thing that I want to make sure you guys realize, that's liability to you. So if you chose, because it was a tight budget and you made the decision, okay, I'm going to drop this premium by whatever, and then lose half of these benefits or whatever, and the family realizes that you did this sometime down the road, and they say, wait, that guardian just lost $250, $350, $450,000 worth of benefit. It's basically like walking into Wells Fargo and losing $250,000 that they had in their checking account. So just be really aware. I always talk about benefits as when you think about benefits, pretend that you see dollar signs. It's one and the same. Because if you think that insurance isn't that important, then you don't think that money is important in the bank either. So be real. I just want guardians to be really protected when they make these decisions about long-term care. That's my 2 cents.
Yeah,
And I think
I'm sorry, I have a question to piggyback on that. Can you please update me and clarify? Fortis was a company that myself and other people had policies with back in the 90s, and some of us were young. And I have not had a rate increase since, I guess, 96, the Castlebaum law came in effect. Long story short, about 5 years ago, our local paper here ran an article, how many all the policies were increasing, every year, 20, 40, 50%. I've not gotten a rate increase. Can you clarify the insurance commissioner? My understanding is that book of business, when that policy was written, let's say 90 to 98, I don't know how long those happen. And if they cannot go to the insurance commissioner and say, we need to have a rate increase for this particular book of business, because those people may not be on claim or have passed away.
Well, first of all, if you don't mind me asking, how old are you?
I'm sorry?
I'm asking, so you don't have to answer, but
That question.
No, I didn't hear the question. Go ahead, please. What?
No, that I was asking your age because age has a big part to do with it, because rate increases are based on the actuarial stats of your particular class. So it's possible that maybe you're lucky and the actuaries haven't determined that it's time for a rate increase. But I can assume that one's going to come. So what tends to happen
Depends. Let me just chime in, because you may have a policy that guarantees a steady premium stream. That's possible. There are other policies where you can have your policy fully paid up in 10 years. So it really depends on what you have. And,
okay.
Yeah, and
Well, I had this policy's almost 30 years in effect and early 70s. So again, I'm just waiting, I think, for that. And it's definitely the old policy where lifetime benefits and after 7-day elimination. And again,
Kathy, you understand that that's a piece of gold. You know that? You know what that is, right?
Yes, I do. And I'm not the only one. I have many clients with the Fortis policies. They happen to be older than me, but the bottom line is, I thought, is that true? The insurance commissioner needs justification from that pool of, and how long of the actual length of these policies? Unfortunately, the guy who sold it has passed away.
So to the first point about the insurance commissioner, so yes, you're absolutely correct. The insurance company is going to have to go to the insurance commission of the state that you purchased the policy in. They bring their team of actuaries and they put on a big presentation about why they require this particular increase. And they'll have to show that if they don't get it, they can become insolvent. And the state ultimately either approves or rejects it. So what's happening now is the insurance companies are going to the commission. They're asking for these massive amounts, and the insurance companies are realizing that most of the time they have to acquiesce and at least grant partial approval of some of these rate increases. But what's also happening is, because the commissioners realize just what their decision is going to mean for senior citizens, they're also requiring some of the insurance companies to provide these compromise options. So your very valuable policy reminds me of another person that called our office. She's out in California. Her policy is currently valued at $800,000 to $900,000, but her insurance company has been granted a rate increase, and now she's at $18,000 a month, a year. Sorry, excuse me, $18,000 a year in premiums. And the problem is that the options that they've offered her are terrible. So she's stuck in a pretty bad spot of, well, do I pay this $18,000, or am I taking a saw to my benefits and cutting it down by half. So people are in a really tough spot. And, people always ask, there's lawsuits, what can we do? And I always say, well, I wish that there was, but the state's really approving a lot of these rate increases. But part of what I always follow up with is, well, let's talk about your health. Let's talk about how old you are. Let's talk about if you have any issues. Because a lot of these policies have waiver of premium provisions. So if you take the waiver of premium provision and look at it in terms of, how easy it is to actually qualify, if you're getting up in age and you've got a few issues going on, maybe you should consider activating your policy. So then we'll go through the routine of, do you need help with bathing, or how are you managing dressing? Exactly like I said, well, I stand on the side of the bed and I grab the chair and I hold my wife's hand. I say, well, sir, I think maybe it's time to use your policy. And, you get the added benefit of some extra help. You get the waiver premium. You get to keep your benefits intact. And, you don't have to make a compromise. And a lot of times people realize that, yeah, maybe I should get some help. And it's also not that they need to receive assistance 24/7 every day either. 2 or 3 days a week for a few hours here or there goes a really long way and is enough to keep your waiver of premium benefits going. So we also try to articulate that to people, is that, there is always a different option here. It's just whether or not you're open to starting to receive care. And what I'm finding is that people that, say to me, maybe I am ready to do it, they're staying healthy for longer. They're still functional. They're getting help. They're not, at risk of, if someone falls, they have to pick them up. They're protecting themselves because they know that someone's there to help them. They wait for the aid to get there, and they bathe when the aid is there. That automatically reduces some significant risk of getting injured. So,
Yeah, and there's statistics we almost always cite when we're presenting to groups, primarily insureds, and that is that 50% of the policies, 50% of the people who own policies will die before they ever use them at all. And something like 65 or 70% of people who are using their policies will die before they use up all their benefits, which means that people are starting too late. They're starting too late. So if people activate their policies sooner and they get into a regime where they can remain active with help, they're living longer and doing much better. And actually, Kevin's statement about about the increased premium issue reminds me of a case. I'll tell you very quickly. A man came into me, I don't know, 5 or 6 years ago. He was around 70, so that's pretty young for somebody to go on claim. But he was complaining bitterly about his premium increases, and all he wanted to talk about was that he had no concept that he was going to try to activate the policy. And I'm talking to him, and he starts to reveal all of these medical issues that he has. And I said, well, I think you qualify. To make a long story short, we got him qualified. He had and has an indemnity policy, like Kevin described, that's kicking out something like $14,000 a month. So here he came in for a consultation to figure out how to undo his policy, or get around, or dealing with his premium increase. Should I keep the policy or not? To being on claim, getting good care, and getting a $16,000 or $15,000 check every month. So it's a pretty profound outcome for somebody who had no concept of what to do with their policy. I also want to just really quickly back up to the cognitive impairment issue, because I don't know what the conditions of your wards are and why they need the kind of oversight that they're getting from you. But I suspect there's some behavioral issues that are involved with a lot of these people. And the cognitive impairment trigger, it can include people with psychiatric illnesses if the psychiatric illness has an organic component to it. So that's a very complex concept, but we've had people who've come in who are bipolar or all sorts of psychiatric conditions. And if we consult with the neurologists and the neuropsychologists, and they can link up the behavioral issues to some organic process in the brain, bingo, we have a claim. So I want everybody to be mindful of that.
He's the particular case he's talking about just so happens is that particular insured actually has a guardian. So I think it's
Yes.
extra relevant.
Yeah.
In this case.
May I ask another question? If someone is triggering the ADLs or the cognitive impairment and is significant, but yet they won't give up their driver's license, they won't stop driving, would that deny them the care under these policies?
I'll start with ADLs only. There are plenty of people who require assistance with some of the ADLs that still drive. You know, that doesn't mean that you don't require assistance in the bath or to get dressed just because you can get in the car. And likewise, you know, a lot of people, it may take them a while to get in and out of the vehicle, but they can still drive fine. So for functional cases, there are people that can still drive. It's like the case that we discussed earlier with the doctor or the person who just needed some assistance in the morning.
Who was a doctor, by the way, a practicing physician.
So for him, his issues were in the morning, but after that, he was more functional. He was more independent, and he got in his car and drove. So in that case, you know, he was able to drive and maintain some level of independence while also qualifying. Now, the cognitive impairment trigger is a bit different. It's very difficult to argue that someone that's, quote, requires supervision because they're a risk of harm to themselves or others is still driving. And one insurance company in particular, they absolutely refuse to pay the claims if the person is still driving. They always do. Now, of course, there's certain circumstances where maybe the person drives from their house to their neighbors every day or to the golf course in the neighborhood. But it really is difficult to argue that someone requires that level of supervision while they're still driving. Now, a lot of people are driving when they should not be, which is a different story. We've had people come to the office and say, you know, my father has some obvious issues, but he's not stopping to drive. Well, in those cases, we'll still put a claim forward because I think that speaks to the person's bad judgment because they've been told not to drive. They know that they should not, but they still are. That's a different circumstance. But if someone's just driving on their own and no one's, you know, talked about the fact that they should not, then it is difficult to make a claim. And we've had this conversation with doctors all the time because doctors are very wary of saying outright they should not be driving. A lot of doctors like to hedge. This particular case, a doctor said limited to the neighborhood. Well, you know, if the doctor feels that you shouldn't be driving, they need to articulate that. And I think the family also has very difficult time being honest with people. No one wants to tell their parents you can't drive anymore, but at some point it's the right thing to do, and you're going to have to do it. So it's complicated, the driving issue.
Thank you.
I have a comment to the whole guardianship thing. So if a guardian was trying to purchase long-term care insurance on a ward who had been adjudicated incapacitated, either limited or plenary, long-term care is not going to write that policy because of the order of incapacity, I presume. But now that what you're saying, that, you know, if they don't have specific ADLs and if their cognitive impairment is sort of not that easy to show, it never occurred to me until you're talking right now that it is possible that a guardian could purchase long-term care insurance even on someone who's already been adjudicated. Is that true? Am I right?
I think you're 100% correct. I'll give you an example of a young man who we know who is on the spectrum and also has a seizure disorder. And I think he's probably around 30 years old. His parents wanted to purchase a long-term care insurance policy for him. And it was rigorous to get through the underwriting, but he got approved and he has a policy. So it is possible.
Wow.
Yeah, he's working. He works. He's somewhat independent, although he does have needs oversight. His parents need to, you know, make sure that he's okay. He got a policy.
Wow, that's so interesting because like we often get named as the guardian advocate of younger, well, developmentally disabled folks who then you know, the parents passed away or something. And I always just presumed that those diagnoses would stop them from ever being eligible for long-term care, but not necessarily.
So
Wow.
that's definitely a nuanced case by case determination,
Yeah.
but it's possible.
Yeah.
So if anyone has any other questions before I'll switch back to a different slide.
I just
So-
have a comment. I'm sorry, just a quick comment. Is it a third party that several people may not know that they need to have another person beside themselves get notified about the policy on it? I know it's a special form with John Hancock. And also to encourage everyone to make sure their premiums are ACH deducted from their checking account so they don't miss a premium and the policy lapses in case the person becomes temporarily incapacitated and the bill doesn't get paid.
So you just laid me up for my next topic because premium increases always leads into issues of lapse. So to your first point, yes, every insurance company allows you or has to offer you the option to designate a third-party addressee. So what that is they'll say, please give me a specific person that I should notify if your policy is at risk of lapsing. And a lot of people make the mistake of not choosing someone or not updating it. I get so many calls from people that, they named me as the third party, but I haven't lived in that address in 12 years. Well, I mean, the insurance company's not going to chase everyone to make sure that it's accurate. So what they do is every 2 or 3 years, they have to offer you a new one. So we want to make sure that they're constantly accurate and updated because lapses happen all the time. And then to your second point about the ACH, I still think even though it's on automatic deduction, you have to be diligent about making sure that it's been pulled out. I have a lot of cases from people that they had insufficient funds or changed bank accounts and didn't remember that I was on ACH automatic, and they got a lapse, even though they fully intended to pay. So on this particular issue, you really want to make sure your premiums are paid because lapses are very difficult to undo and they're catastrophic. If you think making a compromise because of premium increase is bad, well, imagine thinking that you're insured for $500,000 and then you go and unfortunately you have to make a claim 6 months later, you find out your policy's been lapsed. That happens all the time. So we tell people to be extremely diligent about making sure that your premium third party is named and that you're making sure that your payments are being paid properly and on time.
So we were presented with a case, by a POA, a power of attorney, on behalf of an insured person. Probably needs a guardian for sure, but so she had a policy. She along the way received this is like brings it 3 or 4 of these concepts together. This one case, like a law school case. She had this policy for many years with Genworth. She receives, premium increases. I think she absorbed the first one, and then the second notice came out a few years later with all these complicated options. And she writes on the option form, cancel my policy, and sends it back to the insurance company. Long story short, they canceled her policy. So she canceled her policy. Within about a year after she canceled the policy, she has an accident and she's diagnosed with severe dementia right after the accident. So we got the case, and the question in our minds was, did she have the dementia at the time that she was presented with these options? And we had a question about the clarity of the option form. So somebody with dementia, and because there was some ambiguity in the option form, maybe that's how we can get in there and get her policy reinstated. So we put this together forensically by talking to a lot of people, including her CPA of many years. We actually got an affidavit from her CPA saying that during the period of time in question when she said cancel, this lady was not understanding even the simplest concepts about her tax returns. And then there was also a huge gap in her medical treatment. She had no medical records at all for a year and a half or 2 years. She wasn't going to the doctor. Now, when she's in the hospital and diagnosed with dementia, she comes under the care of a very qualified neurologist. And we were able to get an opinion from the neurologist that based on her presentation today and the course of that particular form of dementia, could he relate the dementia back to this date right here? And if so, was she competent to make a decision about lapse or not lapse? And we got her reinstated, and straight away, assisted living, her policy came back into force, and it covered the whole thing. So cases are complicated, but they're doing.
Wow. Okay, and I want to talk for one thing. Guardians are in a strange position because there's a law that talks about how we can't borrow or lend money to a ward. How does it relate to long-term care? I got appointed ETG on a Friday morning, get to the house, going through all the stuff. And part about being a guardian is priority. What's on fire? What's the most urgent fire? And what's a little bit thing you can put off? You know, it's 6 o'clock in the night. I'm still cleaning all through the house and I find a long-term care policy. Nobody knew that she had a long-term care policy. So I'm going through all the bank accounts, trying to find if she's paying premiums. I can't find a single bank account that shows she's paying the premiums. Now, this is, of course, during the age of time where I was finding paper in the house. This isn't internet online banking, which is a whole different world. But so I'm looking through everything. I can't find that she's paid it. I call the insurance company, and for some reason, they were willing to talk to me. I don't know why I convinced them, but they did. That was Friday. Her 6-month day was Monday. I made the decision to take my personal Amex, my own personal Amex, and pay $2,600 of back premiums because I knew what she would lose. And I figured I'd rather get in front of the judge and be in trouble for lending money to my ward than losing $500,000 or more of value. Now, I had a great attorney, and I called her and told her what I did, and she had us before the judge that following Tuesday, and she told the courts what I did and why I did it, because technically that's illegal. I'm not supposed to loan money to the ward, but I dang sure did, because I've understood that 6-month line is pretty damn hard to get over, and I didn't want that to happen to her. So had I not, could I have been sued? I guess, but worse than that, she lost all that money, and I had great care for her for the rest of her life because of that. So that 6-month number is super critical. And now that we don't have the advantage of paper statements coming to the house, and you don't have her log in to Bank of America or to Chase or to Wells, you don't really know if her premiums are current. And it's scary because you have a tight timeline. So that's an exciting story, Kevin, that you won that battle. I'm impressed at that.
So I'm actually glad, like I was formulating an example in my mind to articulate my next point, and that story is exactly what I wanted to say, is that if you do happen to get involved in a case just like that, and you discover that there's a policy that, may have lapsed already, it's possible to get those policies back in force rather. Now, it's difficult, but if you find a policy like that that's recently lapsed, does not mean that it's the end of that policy. So I think that, a lot of these policies have built-in protections if a policy lapses while the person would have been claim eligible. So if you ever come across a situation like that, you have to reach out to, well, hopefully you reach out to us, but you have to reach out to someone that can help you with that, because there's a way to get that policy back. It does not mean that it's over. So I thank you for that example. It's exactly what I was going to bring up. You're going to say something else?
No, I was just going to say that, the lapse, there are technical statutory requirements that the insurance companies have to adhere to when they're lapsing a policy. Certain language there has to be a certain sequence of the notices that come that are sent. There's so many issues around that, but so we've been able to undo lapses just based on technicalities that the insurance company did not strictly follow the statutory requirements. And then, examples like we just gave about somebody who had severe dementia and didn't have the capacity to understand certain things. So there are a whole array of ways and theories of how to undo a lapse, and we've done a lot of them. So it's doable, and that's as much as I have to say about that for now.
So I only include this slide because it's the follow-up to the premium increase issue, is that if you are considering making a compromise, and I'm sure all of you are already aware of how expensive the cost of care is, but if you're making the decision to compromise a policy to reduce the premiums a bit, you just have to be aware that this money for the cost of care is going to have to come from somewhere. But we like to frame it this way for someone to understand exactly what the compromise is. For example, you have a 4-year policy and they're offering you, well, let's chop it down to 2. Well, you're gonna have to figure out the basic math here of how you're gonna make up that difference. So we try to articulate it this way so people fully understand some of the options that are being provided to them. And then I think just generally, we'll just talk about the importance of relying on people that really know what they're talking about, especially for long-term care insurance. And I think it's pretty obvious, policies are, like I've written, complex legal contracts. They're written by attorneys. They're purposely written with ambiguities. They're vague. They're not made for the normal person to understand it. And I see it all the time. We get people in our office, they call, they say, the person that sold me, and it's always, they sold me the Cadillac of all policies, but they have no idea what is actually in it. They were just told this when they bought it, but they don't have no idea what they're actually reading or how it relates to them. So you want to make sure that you're understanding the policies. And if you don't understand a particular policy, you want to make sure that someone who can help you does. Another issue is that the policy language may not necessarily conform to the law. I think this ties into the nursing home only conversation we were having. But just this week, I have a policy that has a provision that the insurance company is still applying. They've denied this person on the basis of his particular policy requires him to be in the hospital before they'll pay benefits. Well, under the law of most states, a provision like that is no longer allowed. So, and the policies, they don't issue new ones. They don't keep up with the law. It's a complicated legal question. So if you don't know the law and you don't know that the law's changed, then you may not even be reading the policy correctly or understanding exactly how it should be applied today. So that's a really nuanced issue, but that's just part of why sometimes it's better to rely on experts than to try to figure out yourselves, because even if you understand what you're reading, it may be outdated and no longer apply.
I want to elaborate a little bit on this. Policy language may not necessarily conform to state law, because someone asked if we could supply you with the law that says a home care only policy
nursing home
only policy should apply or can apply to assisted living. And likewise, how does a home care only policy work in assisted living or outside of home? We're not going to be able to supply you with a statute that says a nursing home only policy should also apply in assisted living. It takes pulling from different sources in the law to make that happen. And so, for example, in a nursing home only policy, the first thing you have to do is you have to look at how the policy defines nursing home, because nursing home only policies don't necessarily say that they have to be a licensed nursing home. They define nursing home. And if there is an alternative care setting that meets or substantially meets the policy definition of a nursing home, then we can come in and make the argument that for the purposes of coverage, this assisted living facility is a nursing home. That's how you do it. And likewise with,
well, I think just to that point, just to give an example, and it's a crude example, but just so you understand, a policy may say, we will pay benefits in a nursing home. And then they'll go on to say a nursing home is a place where seniors live and they receive assistance with activities of daily living, and there's an RN on staff. Well, that definition is basically assisted living. You don't know that, and you don't know that that's the definition under the law, then you're just going to take the insurance company's word for it and believe that only a nursing home would be covered. So those issues arise all the time where nursing home may not necessarily mean nursing home. So it sounds a bit odd, but there's tons of this loaded language in the policy, which doesn't always match up with what's in reality.
Yeah, and the home care only issue, like Kevin mentioned earlier, that was my father's case where, and by the way, he had a old policy form with Fortis. Somebody out there mentioned Fortis. So, and there are a lot of variations have evolved from my dad's case, but we had to put our father in assisted living, and he had a home care only policy. And there were multiple arguments that we made in that case, but really the core argument was that as a matter of Florida law, and it's pretty much standard around the country, but for sure, as a matter of Florida law, assisted living is considered to be a person's home. They can live independently in assisted living if they want to. Of course they can. They have their own mailbox. They can come and go as they please if they have the capacity to come and go like that. So, and by virtue of their license, the ALF is required to offer their residents assistance with their activities of daily living or supervision for a cognitive impairment. So that's really what I brought to the judge, to the court. My father's living in his home. It happens to be called an assisted living facility, but as a matter of law, it's home. And the court said, yes. And there have been many nuances. Now there is a published decision in a case I was involved in, very similar. So we do have actually a published decision. It was a case that went, it was in the federal court system, and it went to the 11th Circuit Court of Appeals. And that was a case, again, where somebody had home care only and was living in assisted living. And the court in that case ruled that that the way that policy was written, the insurance company had to pay benefits, home care benefits, to this insured in assisted living. So we do have some established legal precedent there. But anyway, I think I'm going a little bit far afield.
I have two more questions, guys. So going back to elimination period, sometimes I'm unclear as to when you can start burning up your elimination days, how far back. So if I'm 65 and I fall and I have to have knee surgery, but I don't really have ADL issues, I just have to have knee surgery, get the knee surgery, have my rehab, and then I don't file a claim for 20 years. How far back can you use your elimination period days to burn up that? Is it a one-time thing?
So most of the policies give you 180 days to meet the elimination period. But once you meet it the first time, then that's it. For a lot of the policies, even if it's years down the road, they'll say, okay, you've already met it, you can restart. But they give you a time frame where you must, like, if it's 90 days, you must complete it within 180. But if you get to that 90, you can go off claim, wait a while, and you still get consideration for already completing the elimination period.
Yeah.
Okay. Another kind of quick question is, I've always made it my policy that I consider long-term care insurance an asset, and I always would have a value created based on, if we used it for the whole use of it, if the policy was, if it had a 3-year time limit, and we would roughly estimate the amount of value it would have, including the 5% increase based on, the value increase every year. And we would file that as an inventory item because as far as I was concerned, it's a value. I don't know if everybody does that, but that's what we did. So if I was going to buy long-term care insurance, how, besides the insurance agent, who is not necessarily who I want to get my advice from, you guys talk a lot about the wording of these policies, which is what actually makes them so difficult. Do you, and as part of your service, consult when people are about to buy a policy and help them understand? Is that part of what you do?
That's a good question. Yes, we do get a few calls for people that are looking to buy ones. A lot of the newer policies are a bit different. I personally think they're a bit better, where they're now hybrids with life insurance plus long-term care. So they're a bit different, and I think they're more comprehensive, but they also tend to be very expensive. So people do like to bring it to us and ask us our opinion about the long-term care portion. So yeah, some people do present potential products that they're buying to us for review.
Not enough people do that, though, I think.
Yeah, I think more should. I personally have read a bunch of the hybrid policies, and I have a very hard time feeling like I can assess the value of them because you've got disability, you've got life insurance, you've got long-term care all squished together. And I find them very complex and hard to determine what I'm saving and spending. Last comment is, back in the guardianship realm, is thinking about whether a guardian should get court order to either cancel a long-term care policy for whatever reason, or B, accept the premium hike to keep the existing policy. I think guardians should make it their habit to talk to their attorney who's representing them and say, okay, I have choice A or B here, and then here's why I think it makes sense to cancel. Here's why I think it makes sense to agree to pay the increased premium. I think the safest avenue, guardians, is for you to just get court order, get your attorney to file the petition and get court order, especially if you can get consent from the family saying, yes, this is a good decision and here's why. Because you think we don't understand long-term care insurance? Guess what? A judge doesn't understand at all.
Yeah, I think you're absolutely right. I mean, I think anytime, a fiduciary is making a decision like that and can get, court approval, then they should.
Yeah.
That's
Yeah. Oh, I know. I know what I want to say about inventory. The other piece that I do for my process is every long-term care policy any of our clients had, we always put it in our calendar that every January 1st, we sent a letter to them requiring the insurance company, John Hancock or Genworth or whoever, to give us the current value, because if they've got the 5% increase, we don't necessarily know what the daily rate is, and their math is very interesting. So we always made them send us a physical letter. So we had the actual letter to say, okay, as of this date, she's now up to, $270 a day or $2 whatever a day. Because I always get worried that I don't know the real value and when they're going to increase it based on the age of the policy or the calendar year. I just don't feel like it's easy information to figure out.
And I've got two quick last questions. Can you move out of state with some of these policies, number one, and have some of the insurance companies gone out of business? I know for a fact that they may have. And also, this is a really odd one. It may not be in your scope of being comfortable to ask, but I knew of a client of mine, I apologize. I knew of a client who had a long-term care policy. They were using a home health agency, and the aide would instead of being there all the time, would leave. So what about fraud? Is anybody a party to being fraud? If, how do we avoid anybody being fraud, and where does that chain go?
Okay, so we'll start with the first question was about taking these policies out of state. The answer is yes, you can take them out of state. They travel. We have plenty of clients that started in Florida and decided they wanted to move to New Jersey, be closer with their family. I have one particular person on my mind. She's a little crazy, so it's making me laugh. I apologize. But yeah, so she took the policy out of state, and a lot of people relocate, and the insurance companies will cover you out of state. There are some nuances there because each state has their own definitions and different bodies of law about long-term care insurance. But the short answer is yes, you can travel with them. You might have to remind me of the second point here. Oh,
out of business. What about the insurance companies going out of business?
Yes. So yes, some insurance companies have gone out of business, and a lot of insureds, when we give these talks, are always worried about it. I think they spend a lot of time online, Googling my insurance company's financial health. So yes, it's definitely a concern. Part of that has to do with why these insurance companies are being granted such big premium increases, because if a particular insurance company does go out of business, the insurance commissioner of the particular state where it was issued is on the hook for a portion of it. Each state has their own insurance guarantee association where they will back up your insurance company if they go out of business. The problem is the limits of the insurance guarantee association are oftentimes much smaller than most of these policies provide. Yeah. So we have some people that have called us very worried. I have a very big policy of $700,000. What happens if they go out of business? I think in Florida, the cap is about $350,000. And I think that's one of the higher amounts in most of the states. So the answer is you'll at least get some protection, but you will probably not be made whole on that. And then the other issue is that they're just not going to pay that out. Most of the time, you're still going to have to qualify like you otherwise would. You're going to have to deal with additional bureaucracy of the state being the person to the entity paying these things out. There's one insurance company in particular that's currently under receivership, which means they're not necessarily insolvent, but the state's taken over and is watching them, with significant oversight to make sure that they're not going to go under. So that insurance company has become a little bit difficult to deal with because you lose some of your rights as the insured. I think there's a stay for that particular insurance company, which means you can't sue them. So you lose some leverage, and then you're also sort of at the will of the insurance company in the state at that point. But a lot of the major insurance companies now are in better financial straits, and that's why they're pumping up these premiums. But they also have a lot of assets under management, especially the big name brands that you may know. And then the third point about fraud. Fraud is a very big problem. The insurance companies spend a lot of money and a lot of time doing their research to investigate fraud. We've had plenty of people call the office where they're being sued, they're being threatened with criminal action, they're being threatened with losing their policy because of fraud. So it certainly happens all the time. It happens a lot, especially if someone's using their policy when they're a bit younger. The insurance company is going to be looking for you. If you're in your 60s and you're making a claim, they're following you. We had one particular case where her policy allowed for an independent caregiver, which is always another big red flag. If your policy allows for it and you're of a certain age, your insurance company is going to investigate you. So this person hired their independent caregiver. She got approved. They were paying benefits for quite some time. And eventually the insurance company, we've paid $350,000 already. It's time to figure out, do our due diligence here. So they ended up catching her that at the time she was receiving assistance, according to her invoices, they used a transponder from her car to prove that the aide was here in North Florida and the other person was in South Florida, and all of these instances of fraud. So it's problematic, and the insurance companies are checking for people. So we tell people to be very wary about using independent caregivers, to be very careful about, signing timesheets to make sure they're accurate, things like that. And it's certainly an issue.
I had another case in California, same kind of thing. A lady from California called me. She had cancer. She was very ill, and she had a private caregiver. The private caregiver arrangement is very, very vulnerable to cheating. Anyway, make a long story short, she had a caregiver, private caregiver, and they were putting in for 12, 13, 14, 15 hours a day. Okay, maybe her cancer was that debilitating and so forth. But the insurance company started to investigate the caregiver, and they learned that the caregiver was the top producing real estate agent in her real estate company in California.
Oh
no. This caregiver was everywhere but where they said she was. And the insurance company wanted to kibosh this lady's policy. They want to take it away. And we were able to save the policy for her. And we had to renegotiate some of the terms of her contract. And namely, no more private caregiver arrangements, and certain parameters of the types of home health agencies that she could utilize, that they would agree to. But it saved her policy.
Wow.
They didn't claw back any of the money either. And I think
Wow.
I mean, in that woman's particular case, she was needy, and there's often times where it looks like fraud, but it's just the senior saying, "Oh, you can leave early," or "I want you to have more money." That's more predatory. We don't consider that fraud. And then there's other cases where, like the one I told you, where they were both in different locations on the transponder, where the person's cheating.
Yeah.
So there's different degrees to that as well.
No, and I had a case where years ago where a woman came to me. She was already approaching 90, and she came into my office with her caregiver, and so they both come in. They're sitting at my desk in front of me, and the caregiver. We're discussing a certain issue in this lady's policy. She was already claim eligible, but the issue that we were discussing was, we think that the company is significantly short paying the claim, and that there's potentially quite a bit of money involved in reimbursements. And as I'm beginning to tell the story, this caregiver is leaning closer and closer in towards me. So I stopped and I asked the caregiver to please step out, and she did. And then I asked my client, who ultimately became my client, about her children. Where are your children? oh, my son-in-law is a Harvard graduated lawyer and my daughter, and they're in New York. I said, do you mind if I call your daughter? No problem. Call the daughter. And I explained to the daughter that her mother was in my office and that I believe that the caregiver is a little bit too interested in her mother's affairs, and that I'm recommending that they keep a very close watch on this caregiver. Fast forward 2 years, 3 years later, she became my client. I get a call from the daughter. The caregiver has stolen $150,000 from my mother. The caregiver was taking my mother to the ATM machine every other day, blah, blah, blah. And I turned beet red. I turned beet red. I told the daughter, I freaking told you to watch this person. Lesson being that
She needed a guardian.
she needed a guardian. She needed somebody to watch. Never rely on the caregiver to be your guardian, or to be, to make, the caregiver is a caregiver, and then the caregiver needs to be overseen as well. There are so many people who are vulnerable out there, as you know, because you represent those people. You're, fiduciaries for those people. That
Right.
was a horror story.
I have a question in relation to private caregivers. It's kind of often that as a guardianship, we take a case and we inherit private caregivers that are in the house, been caring for the client for 3 weeks, 3 months, 3 years. And we really don't want to dismantle their life. The caregivers we believe are giving good care, but they are private caregivers. I use the company that's called Team. They're a domestic payroll company, but they're not licensed as caregiver agencies. So I'm wondering, have you ever used a domestic payrolls company to meet the criteria of the caregiver being a caregiver, because they're not under an agency, under ACA, but the domestic payroll company actually qualifies for all the payroll issues? Would that work, do you think?
This actually came up this week. Someone called, they have an independent caregiver, and she has her own LLC, and they were asking if they think we could get her approved as a home care agency as it's defined in the policy, but it's quite difficult because the policies define home care agency, pretty stringently. It's hard to get around. If it's licensed as a home care agency, you're not going to meet that criteria with either a company or a domestic payroll.
Unless they're
company.
licensed. But you're describing almost a registry type of arrangement, but maybe not, because
No, the teams function, just if you've ever used them, they typically work with trusts. And trustee says, we're hiring whoever to do whatever, but we want workman's comp, general liability, payroll taxes, background check, blah, blah, blah. None of which comes under ACA or licensure, but it does take care of the whole employee situation. So we started using teams like that on multiple clients, especially trust clients. But we have successfully done one long-term care claim where it was a team. They were caregivers that have been with the family for years and years and years. No license, no HHA, no CNA, no license of any kind. We were able to get them on Teams payroll, submit the actual payroll, and they paid it. Now, that happened to be John Hancock, by the way. So I don't know if that was just pure luck or whatever, but that was what we did.
So you're actually on sort of a similar strategy that we're on. So this person that we're dealing with this week, my suggestion to them was, well, if you're an independent caregiver and you have your certification to be a home health aide, if you go through a registry, you can set up an arrangement where you can work for them through the registry and you can be his only client. So that gets them the approval as a home health care agency. Also deals with easier billing for everyone. And I think that's what's going to be happening. So it's a very similar situation. And the insurance companies will have to, consider that the same way they would a home health agency.
Yeah, I think in your case, there must have been a private caregiver provision in that.
Yeah, well, that particular policy was one of those ones that it didn't exactly say it, but it didn't exactly not say it. So we were able to kind of squeeze in. One more question. What's the clarity on coordination of benefits? I've had multiple clients with more than one long-term care policy, and I never am comfortable. Do I fire one gun first? Do I fire both at the same time? If you have coordination of benefits with any other kind of insurance, they're always pointing at each other and saying, no, they got to pay. No, they got to pay. So is long-term care just like that? And are there any ways to know what to do about that?
Well, in the office, for the most part, our clients that have multiple, we double up on a lot of them. But also it really depends the amount of coverage available. Most of the time, if you have two policies, one wouldn't cover the entire charge of, let's say, a month. So we use the other one to supplement it. But there's strategies around which one makes more sense to use, but you can certainly use two at a time.
But they're so they're not allowed. Blue Cross, John Hancock can't say you got to use your Genworth policy first. They're standalone, have nothing to do with each other, correct?
No, but you have to be careful for duplication of benefits.
Okay.
In other words, because a lot of the policies will have that language in it that they don't duplicate. So if you have Genworth paying $100 a day for $100 worth of care, you may not be able to get Blue Cross Blue Shield to pay for that same thing, but you may be able to. Again, it's policy nuanced. So you just have to look at both instruments, carefully. And maybe you can.
Simone has a question in chat that says, in Palm Beach County, the private caregivers have to be registered with the county if they are not, well, she said CNA, I think she means, or RN. Then she says, do they do the background checks? Well, Simone, I have a question for you when you say they have to. You mean what? The caregiver police are going to come hunt them down? Who actually, if you're just talking about not a guardianship and just a person who hires a caregiver, you're saying that Palm Beach County requires caregivers to be registered? I don't know what you mean by that exactly.
That is correct. That because of so much fraud in the community, Palm Beach County requires that anybody who isn't registered, like a CNA or an RN or an LPN, if they're working for an elderly person, they have to be registered and they have to wear a badge. And if they don't wear a badge, if the police come around or they see them in the bank or the store and they're not wearing a badge and they can ask them for it, there is a huge fine to the person.
Really?
Yeah, that's just in Palm Beach County.
Wow, I have never heard of that.
So
wow.
When I have inherited clients, when I have a new client, whether it be case management or guardianship, and there's a private caregiver and they're not a CNA or an RN or anybody like that with a license, they have to speedily get to the county to register.
They register with the county?
With the county, and then the county does the background check. It costs them about $100.
What office in the county handles this? Do you happen to know?
It's where you do your driver's license and things like that, if I'm not
Really?
mistaken.
We also have a question about how long has that been?
Probably well, it was started before COVID, so it's probably 5 years, could be longer.
Wow. If anybody's got a copy of those regulations, let's try to share those. I have never, ever seen that. I'm curious how that actually works.
Find the pamphlet. I will certainly send it so you can.
Thank you. Okay, guys, it is 4:38, which means we are technically done on time. Kevin, is there more stuff you guys want to talk about or are you pretty much wrapped up?
I think the last slide was just the process of getting an attorney engaged. I think most of you are just aware, but if you were deciding to hire an attorney on behalf of the ward, you have to bring, obviously you have to petition, also explain, the basis for it. And then the important part is what happens in our office is get any agreement also approved. So we've sent our copies of our retainer agreement for approval by the court. And I guess that was a very abridged version, but I think it's probably unnecessary to go into detail because I know we're up against time here. But if anyone has any questions, I'd be happy to spend whatever time we have left on that.
That's good. So this was so helpful. I keep thinking I understand long-term care insurance. Every time I learn more, and this was phenomenal. I've learned a lot. And I think we as guardians need to get the attorneys that represent us to take these presentations because we need them to help us make the right decision and help us stay safe as what's going to happen that we're going to get in trouble for, or we didn't take care of our ward properly. All right. So does anybody have any last questions? Because we're just about the end of time.
We got a couple of people just saying that it was nicely done and thank you.
Thank you so much. I appreciate it.
Okay, Kevin and Stephen, thank you guys so much. I will say again, and I am praising them because they saved me with a client that I fought that battle and couldn't win So I was so happy to have them. And ever since then, we talk to each other a couple times a year, asking things back and forth. So they've done a great job. And now that Kevin is in his dad's group, I'm so glad, because, you know, his dad may decide to retire sometime, but Kevin's not allowed to retire. So there we go.
Never.
Never. That's right.
You might come to the office with a caregiver, but that's about it.
There you go. Why not? Why not? Okay, guys, we had a really full house today. If we want to end the recording and then people want to just kind of talk for a few minutes, we can do that. Or if everybody just wants to log off, we can do that too. So let's see what people want to do. Is there stuff that people want to talk about? Go ahead, Julie.
I'm going to pause it. I'm going to stop the recording anyways at this point, but we can make a decision from here. So